Before the short adjournment, I was just finishing with the idea that we've got a legacy of a historical development in the evolution of the various rights engaged. And I was going to move to the extent and nature of impact on persons such as these appellants and deal with that at this stage. It obviously goes ultimately to the balance between the various interests that are engaged when you come to that stage under Article 14 and the impact whilst Parliament considers what to do about the difference of treatment that was created by the 2014 Act. And we make 4 points about the nature of the impact on persons such as these appellants. And the first is that in the present context, we are dealing with the extent and nature of impact and difference for as long as the current and ongoing review lasts by Parliament. Both the Government and Parliament are evidently committed to consideration of the nature of the changes that should be introduced rather than whether changes should be introduced to deal with that difference. Secondly, at a basic level, their position during that period remains precisely as it has always been. The difference in terms of the legal availability of rights and obligations and institutions is simply about whether they can access the recently created civil partnership institution. But as we saw in the review of the evolution of our law, the law has never afforded opposite-sex couples that status or equivalent alternatives to marriage. And as we also saw, there is no requirement to do so under the ECHR. The institution was created simply for the purpose of equalising same-sex couples' rights at a point before society was ready to recognise those relationships as marriage, not in recognition of any more general need to create such an institution. Thirdly, their case is not that Parliament is required to extend civil partnerships to opposite-sex couples. That is not their case, even though the only objection they raise is to marriage as an institution. So they accept that if, and it is one of the options, Parliament simply abolished civil partnerships, the difference would disappear, and they could have no complaint under Article 8, and the sole basis for their Article 14 complaint would disappear. And that creates a real issue, an irony, as it were, at the heart of their argument.
Well, presumably somebody explained that to them before they began these proceedings.
Maybe they did.
If you complain of discrimination, you could always either level up or level down.
That's true, but Parliament and the Government are seeking evidence to enable them to decide whether to increase, inter alia, to increase the range of legal recognitions. If that were to be the decision, and indeed only if that were to be the decision, would their base concerns be met? Parliament doesn't have to do that, and they are therefore considering options which are well in the vanguard of Council of Europe states. They could simply shut down civil partnerships as, and you've seen from the evidence that this is the position, as other countries have done when they extended marriage to same-sex couples.
Of course, the other thing they could do is shut down marriage.
Well, I suppose in theory they could, as long as there was some form of basic legal recognition for rights deserving of protection.
We'd have civil partnership available to everybody, and anybody who wanted something which they regarded as marriage could have their own religious or other ceremony, but the actual law would depend upon the civil partnership.
My lady, that's true. My only point here is that, as I say, Parliament and the Government are seeking evidence to enable them to judge between various options. The most obvious one, if one took Council of Europe indications, is introduce marriage for both same and opposite-sex couples and then abolish civil partnerships altogether. Well, that wouldn't help in relation to the base objection that these appellants have to marriage. It would leave them simply with what they regard as an unacceptable option. So what government is doing is to seek evidence to enable them to consider the range of options, including, in effect, the only one that would really go to the base objection that this couple has, which is to extend civil partnerships to include opposite-sex couples. That's the third point. And it's an important point, I respectfully submit, because we are in the vanguard here, and it is enabling Parliament to consider more progressive options at that time that is being taken in that evidence-gathering process. And that is the position in circumstances in which, as a matter of ECHR, they could perfectly happily do what other countries in Council of Europe have done, just simply abolish it. But that wouldn't meet these individuals' concerns at all. Fourthly, theirs is, we respectfully submit, a bare difference of treatment, or close to being a bare difference of treatment. It has none of the Article 8 force behind it of those, for example, from same-sex couples who brought the various challenges we've seen in Strasbourg. They are not remotely in the same place as the same-sex couples were, either before step one, legislative step one, the extension of the rights and obligations, or before step two, the extension of the institution of marriage to include same-sex couples.
Before the short adjournment, I asked you whether incompatibility arose on the coming into force of the 2013 Act. If that, on reflection, was a wholly wrong question to put to you, and I'm going to ask you a different question, and that is, on the coming into force of the 2013 Act, did the inequality of treatment between same-sex couples and different-sex couples arise immediately?
My Lord, the difference of treatment did.
Yeah. Well, did it call for justification at the time that the 2013 Act came into force?
From that moment, that difference of treatment was created and felt to be justified. I accept that. The question is how one, the real debate in principle is how one can go about justifying it. Is it possible and permissible to justify it by matters that are, as it were, not intrinsic to the difference, but by reference to whether or not Parliament can take some time to consider different and progressive options?
So the 4 years that have elapsed since the coming into force of the 2013 Act have been years in which how the inequality of treatment should be cured, not something that is, as you put it, intrinsic to justification at all.
Yes. Well, intrinsic to, that's the debate. Yeah. But my Lord, as you've seen from the cases, no case has ever been built by the government that advances justification on any other basis. The question is whether that can be done, whether that is legitimate.
Mr. Reedy, of course, the appellants issued their claim in December 14,
yes,
3.5 years ago. Over the short adjournment, I've taken the opportunity to read this. I'd had in my mind, well, September 2019, it's all going to be sorted one way or another. I was wrong about that. Paragraph 29. Once these activities are completed, the government would be able to bring forward a set of proposals for how the law should be changed as part of a full public consultation. And at the earliest, and I read it first of all as at the latest, at the earliest, we would anticipate being able to consult on the future operation of civil partnerships in 2020. So 3.5 years so far, and another 3, 4, 5, 6, makes perhaps 9 years of their waiting. And if one of them were to die in the interim, serious economic repercussions. What do you say about that?
My Lord, what I say about that, what I will ultimately say about that, is that, of course, there is a question as to whether or not Parliament has exceeded, and the government, through, as it were, with Parliament, have exceeded a reasonable time for sorting the difference. I'll come to address you on why it is that it's taken that chunk of time, particularly in the light of Section 15, which you saw from the 2014 Act saying, do the review immediately, as it were. So there is a burden to justify that. Of course, the starting point for that is that it is an interesting question. And that means that I have surmounted, is all I meant by that, the in-principle burden, which was the subject of my Lord Care's questions. If it is, I fully accept that there is a burden on me to justify the reasonableness of that timing.
It's not made any easier by the fact that the inequality of treatment is of Parliament's own creation. I mean, it was when it decided to introduce legislation in the terms it did in 2013 that it created the inequality.
It did. And my lord, what that tends to demonstrate, again, I'm jumping a bit ahead of myself, but what that demonstrates in my submission is that at the time Parliament enacted that piece of legislation, it evidently formed the view that it wished to introduce that extension to the rights of same-sex couples at that point. And it did not wish to wait to do that, to confer that progression, that step in the evolution, even though it recognised, as it plainly did, see section 15, that it was not yet ready to address the consequences of the difference of treatment that it was creating. So there are two decisions that plainly emerge from that act. But my lord, I will come to, can I come back to my lord's question in terms of the detail of it?
Please.
Because, but in principle, I accept that there is a burden of justification for that period of delay. As I say, that assumes I've got over the burden of the issue of principle, which my Lord Kerr took me to task on a minute ago.
Yes, quite. And if it isn't justification, then we're into a discussion of remedy. And you'll have to address us in due course as to, bearing in mind you accept that there is an incompatibility, what would be wrong about our so declaring?
I don't accept that there's an incompatibility. I accept that there is a difference of treatment. You know that the stages of the Strasbourg analysis under Article 14 is there a difference of treatment between people in a comparable situation? That is not justified. I accept that there is a difference of treatment. You can call it discrimination for short if you will, but let's not conflate the stages of the argument. I am not accepting that that difference of treatment is unjustifiable.
No, that's what I understood.
I simply don't mount that justification on the basis of something intrinsic to the difference. I mount the justification on the basis that it is permissible for a national legislature in an area of evolving social rights confronting difficult social issues to take time to consider, or if you will, to make a prior judgment that says we wish to take this progressive step first, even though we're not ready to go to the next stage. That's the justification I advance. So I do not accept that there is incompatibility.
If you're wrong about bringing the time for Parliament to sort it out point into justification, then you would accept, hypothetically, that there would be incompatibility. And then my question would be more apt. What would be wrong about our so declaring?
Yeah, of course. If the position is that, that it is not in principle open to a state to rely upon a justification for a difference of treatment, whether it's created it or it's just arisen under law, if it's not justifiable for a state to rely upon anything other than an intrinsic justification, if I can use it for shorthand, I lose. And then the question my Lord poses to me arises. If I can overcome that hurdle, but the court nevertheless decides that the reasonable period for that difference to be sorted has been exceeded, I lose. I mean, you would still have to allow time, as it were, for Parliament to sort it out from here. But at that point I lose and there is incompatibility. At that stage, the may in section 4 of the HRA arises and the court would have a discretion. But it would, by definition, as it were, by then have concluded properly incompatibility. And you can see why, from my perspective, that is the sequential issues relating to the discretion under the Human Rights Act are, as it were, less interesting than the attempted justification of the difference of treatment.
Thank you.
Perhaps we better get there then.
Well, my lady, yes. It's always well to try and answer the court's question if possible, but
thank you.
I'm grateful. So I've made the third of the points in relation to extent and nature of impact. I was on the nature and extent of the difference of treatment and its impact, and the point I was making was that it has, as we respectfully submit, none of the Article 8 force behind it, and that these individuals are not remotely in the same place as the same-sex couples were before step 1 or step 2. And that is because the law has created a status and recognition and consequential legal rights and obligations, all of which they can access without legal impediment. and you'll remember that distinction running through some of the Strasbourg case law. There is no legal impediment. They are thus able, as a matter of law, without a burden or a hurdle to overcome, to access both the institution and the rights. There is no suggestion that any part of the legal framework governing marriage is, for example, inferior to civil partnerships, and even if it were, you'd probably be within the margin, for the reasons I went through in going through the case law. And nor, we respectfully submit, can their objection to marriage properly be said to sound at a place at or close to the heart of Lord Walker's concentric circles. You know what I mean by that in RJM, the concentric circle analysis, defining or describing Article 8 rights, with various sorts of rights and interests being closer to the core or heart of that. And the reason that that is so is because one can have, under the present law, an entirely civil process leading to marriage. No religious element at all. You can have a celebration and a ceremony of marriage which reflects your own particular values and beliefs without any restraint by law or otherwise. They do not have to take their list, the giving away of the woman, white virginal wedding dresses, or even a gender-segregated hen party or stag party. They can, in modern society, and would be taken in modern society as entering into marriage entirely as equals, with equal respect accorded to both of them by law. And the next couple, through the registry office door for good measure, could be a same-sex couple. All of which indicates, we respectfully submit, that whilst, of course, we do not quibble with the genuineness of their objection, and whilst they do consider, no doubt, that marriage comes with patriarchal or other baggage attached, that past, we submit, so far as the legal regime and the ceremonies now attached to it, and indeed the institution itself, is distant indeed in the rear view mirror as the values and law continue down the evolution road. And linked to that point, again, it's important in assessing the degree of impact whilst Parliament, as it were, considers, is the fact that their current inability to access civil partnerships does not indicate, and nor does it imply, any lack of respect for or actual or reasonably perceived devaluation of their relationship. And that is in stark contrast with the same-sex couples and their position in advance of step one or indeed of step two. And you'll see, I'm not going to go to it now, but we've cited in our case Wilkinson and Kitzinger, Bundle 3, Tab 20, 1917, cited in our case at paras 82 to 83, but that involved a challenge by same-sex couples between step one and step two. And what was effectively being said was, well, all right, you may have extended so that there is now equivalence of legal rights and obligations, but we want access to the long-valued, societally valued institution of marriage. And the fact that we can't go there does imply, they said, a disrespect, a devaluation of the validity of their same-sex relationship. And we are not anywhere near that position. And finally, in relation to impact, Ratzenbach, which I took you to earlier, is again of importance on these points. And they rejected the position that the claim there, as you've seen, paras 41 to 42, we looked at them earlier, they rejected the claim on the basis of non-comparability between opposite sex and same-sex couples in a system that was equivalent to ours after step one. In other words, marriage for opposite-sex partners available, civil partnership only to same-sex couples. And their objection was essentially the same as these appellants. See paragraph 9 of the court's judgment in that case. And it's evident that they were not treated as objections of any significant weight. the court's reasoning was effectively that the opposite-sex couples had access to the institution of marriage, and despite that objection, that was enough. There was no claim, as they put it in para 41, that they were specifically affected by any difference in law between those institutions, and that being so, their wording at the beginning of para 42, they weren't in a comparable position. Now, if they had accorded real and significant weight to those objections in that case, it's very difficult to see how that wouldn't have led the European Court of Human Rights to a conclusion that they were in a comparable situation to the same-sex couple. And instead, they found that they had no specific need for anything other than marriage.
Did I understand you to say that Section 15 is evidence that this was a conscious decision that on the part of the government not to extend civil partnerships to different sex couples?
This was a conscious decision on behalf of Parliament.
Yeah, on behalf of Parliament.
When enacting that legislation, that in effect they weren't ready to work out how they were going to address that difference, the difference that they thereby created.
And it does contemplate, it builds in the need for a review.
It does.
Well, what was to prevent Parliament from saying, well, we realise that by introducing this legislation, we're going to create a position of inequality. Therefore, we will extend civil partnerships to different sex couples, and we will then conduct a review.
Nothing. And they could equally well have said, we are going to abolish civil partnerships.
Absolutely.
Which is exactly what the rest of the Council of Europe did.
Well, they could have done that, but one can understand that they felt the need for a review before taking that step. But in terms of justification, if you're right in your submission that Parliament must be given some time in order to come up with the best solution, conscious that it was creating an inequality, how can it be said to be justified that they didn't extend it to different sex couples and then conduct a review, and at the end of the review decide whether or not that position was going to be preserved?
Because there are two ways of sorting the difference of treatment thereby created. It's the short answer to that. In fact, there were three that the government and Parliament were evidently thinking about. Close to new entrants, abolish civil partnership, or extend to include opposite-sex couples. And any one of those would have been legitimate. And any one of those, certainly the abolition in either or both of its forms, closed to new entrants and or complete abolition, would self-evidently have been compatible, because at that point it's perfectly obvious that the consensus in Europe, almost unanimous apart from the Netherlands, is that when you create that difference of treatment, that's what's been done. So what is left, as it were, is considering and allowing time to consider the far more progressive option to get us right in the vanguard of all of this, which is to extend civil partnerships to opposite-sex couples. But I do not accept that it flows from the fact that Parliament must have recognised that it was creating inequality, that the solution for dealing with the difference thereby created could only have been to extend civil partnerships to opposite-sex couples, for those reasons.
Even as a temporary measure?
Even as particularly perhaps as a temporary measure. While all will need no convincing, I'll come back to this point, but you've got to address, if you're going to make a change of this kind, whether it's abolition or it's a phasing option or it's an extension option, you've got to consider the legal ramifications and how that's going to work and what happens if we make that temporary decision today. We alter all the legislation to include this, that and the other, so that civil partnerships for opposite-sex couples then have ripple-out effect across the whole raft of legislation, and then 3 years later we say, well, now we've finished our review, we'll come back, we'll decide to unpick all that. That's the way we put it. But as part of this, and the point I'm on now, is if you reach that stage and you're assessing whether Parliament is entitled, whether this operates as a justification and perhaps indeed how long it goes for, you are entitled to weigh into the balance, and there is of course a balance, the period of time, to come to my Lord Wilson's point, the period of time, to take that as an example, that Parliament has taken to consider these issues to date, and the nature of the impact pro tem. If, for example, during that 5-year, 6-year, 8-year, whatever it may be period, whilst Parliament is taking time to consider it, you are in the sort of situation in which, for example, same-sex couples were in before step one. You're actually dealing with remarkably serious impacts that go to the core of private life. And so it is legitimate and relevant to take into account extent of impact for that purpose. Can I then turn to the decisions by Parliament at the time and the work... I'm sorry.
Can I just check with you? The Section 15 obligation of the Secretary of State, I think, was performed some time ago, wasn't it?
It was.
Yeah, and I mean, we're currently, the paper from last week is really a subsequent exercise.
It's a follow-on from that, and my lord will see from the history. I'm about to go to the history directly, but you'll see that what has happened is that there was a review,
yes,
which was required to be undertaken as soon as possible, which I think are the words my lord is alighting upon, followed by as it were, thoroughly inconclusive. I think, as Lord Justice Briggs pointed out, there was a majority against each of the options for dealing with the difficulty and an inconclusive picture on the statistical evidence. And so the matter was continued, but it wasn't, as it were, continued outside the eye of Parliament. Mr. Loughton MP brought various private members' bills, of which there is a current one before the House.
Yes. Yes.
But so I'm turning now to the decisions by Parliament and the work, the chronology, as it were, since then. And it was against the backdrop of the evolution that I've described that the question arises, well, what was the position that confronted Parliament when it decided that society was ready to open marriage to same-sex couples? That was the big million-dollar question in 2013 or 14 when that Act was brought into force. Well, put yourself back, as it were, to that position, because the nature of the case against me is you've got to do it immediately on the most extreme form of the case that says you can't have any justification which isn't intrinsically linked. That's the prime case that's being advanced, or within a reasonable time, but that means I've crossed the first hurdle. But what was the position at the time? Well, they had civil partnerships, and they've been in place since December 2005, as we saw from the history, for 8 or 9 years by 2014, and they had been used extensively. But same-sex couples can now marry, as from the date on which the 2014 Act is brought into force, and Parliament had decided to take that, and it was, to use the adjective, a momentous step to open the institution of marriage to same-sex couples. And it was a step that was well beyond the requirements in Articles 12, 8 or 14 of the Convention. But it left, or it created, a set of social questions and judgments about what to do with civil partnerships, which have been introduced, as we have seen, as a mechanism, and I emphasise a justified mechanism under the ECHR, even though it only had applied to same-sex couples. It had been introduced as a mechanism to equalise the rights and obligations position and to accord an alternative legal status, not marriage, but an alternative. That's why it had been done. It was justified at the time it was introduced for those reasons, as we've seen from the Strasbourg case law. But there was now a difference that was created by the extension of the marriage possibility. Same-sex couples who could have a choice, civil partnerships or marriage, and opposite-sex couples who would not. But that difference, as it were, was the result of historical step one, the correction of rights of same-sex couples, and led to the need to consider what to do about it. And as I say, that raised social and legislative judgments, what to do with those civil partnerships. And the starting point is, we respectfully submit, that Parliament made, in effect, two decisions when it introduced that piece of legislation. First, that it was not ready, or in its view sufficiently cited, to make decisions about civil partnerships at the same time as taking step two and extending marriage to same-sex couples. That's the first decision it made. And the second decision it made was that it nevertheless did not wish to delay enacting the legislation to take step two. And the second of those is obviously evident from the fact of enactment and readily understandable, as seeking to take the progressive step it did as soon as possible, and, if you will, to take evolution in bite-sized chunks. And the first decision, not ready, is evident from the fact that an amendment was proposed specifically to extend civil partnerships to opposite-sex couples, and it was not accepted by Parliament. So when the Marriage Act was going through, the Same-Sex Marriage Act was going through, a specific amendment of the kind that my Lord Kerr put to me was put to Parliament and was rejected. And the alternative, which they decided was the right answer, was to enact Section 15. It imposed instead a duty on the Secretary of State to review the operation and future of civil partnerships. It prescribed an as soon as possible start date and then a requirement for full public consultation and report. And why was that second decision then reached? What can one tell about the reasons for that? Because in summary, we respectfully submit, Parliament evidently concluded that it wanted further time and evidence gathering before deciding which of the various options for dealing with civil partnerships it wished to pursue. It had the option of amending the law to extend them to opposite-sex couples. It had the option of abolishing them either altogether, leaving conversion to marriage as the only option, or phasing out, leaving those who chose not to convert in place, but no further civil partnerships. And it had the option of deciding it needed more to enable an appropriately informed decision to be made between those earlier options. And so, as I say, if the difference was to be removed, and that was and remains the working assumption, its abolition, close to civil partnerships prospectively, or keep them and extend them to opposite-sex couples. And those options, those three options, if one takes them, abolish, phase out, keep, and extend, those three options only have to be stated in order to indicate the genuine and potentially complex set of social and legislative judgments that need to be made between them. So what then happened, after that initial set of decisions by Parliament, in that context, in that territory, squarely in the evolutionary framework? Well, there was the Civil Partnership Review. We've summarised that, I don't take time on it orally, in our case between paragraphs 11 and 17, and the end result, as I summarised in answering a question from Lord Reid earlier on, was inconclusive data, in effect, in part probably because it was too early for the changes to have bedded down and to see what reactions there would be, and so no immediate change. And then consideration being given to how to take matters forward in terms of gathering information thereafter. So there's the CP review. Then Parliament considers the issue again, and one can perhaps say again and again. See the case, our case, paras 18 to 22. There was a private member's bill in 2016 proposing an extension to opposite-sex couples of civil partnerships. Her Majesty's government explained to the House at that time that they wished to gather more information and considered it too early to tell how the extension of marriage would impact on civil partnerships as an institution, and Parliament agreed. In order to advance a private bill, as I know you'll be well aware, you need to a vote, you need 100 MPs present, as it were, and supporting, and the numbers were not there. In 2017 and 18...
I suppose that counts as agreeing.
Well, my lady...
Not turning up on a Friday to support a private member's bill, I suppose it counts as agreeing. Yeah.
Those are the privileges of Parliament. That's how our democracy works. For good or ill. I know my lady won't have been calling anything on that front into question, but that's how it works. The democratic decision, for good or ill, and however arrived at, was. 2017-18, there was a further bill to the same effect introduced, still too early. But on this occasion, the terms of the amendment the terms of an amendment were agreed so that the bill then had government support and could go forward, with the government taking over the drafting, and that is currently before Parliament. It's expected to go through the committee stage this year, with possible assent in March 2019, is I think the anticipated time frame for that. And if that amendment in that form were to be made by Parliament, you've seen the shape of it in our case, Parliament will be going, as it were, a stage further than it did in 2014 when it introduced the Section 15. It would require the Secretary of State to make arrangements for the report, and it makes, as it were, the explicit premise on which it proceeds is that the government will remove the difference, or Parliament will remove the difference. So that premise is built into that provision, but it's still a decision by Parliament, which they're actively currently considering, as to whether or not they think they've reached a stage where they can say, we've got enough, we can make a decision. And we will.
If we, at the end of all this, were concerned about the still open-ended aspect of this proposed consultation, but felt that it wasn't for this court to start setting a date, might we nevertheless invite Parliament, in considering this amendment, to decide whether to make it stricter in terms of time?
Well, my Lord, you will, of course, need to be respectful of the constitutional divide.
Right.
It's not an unfamiliar issue for this court,
no.
When it concludes that incompatibility has arisen, and I have in mind in particular a case called GC, I think it was called, which my Lord may recall, in the post-MARPA era, about DNA retention, where there had been successive attempts to try to introduce legislation to sort the MARPA problem about what DNA could be retained and for how long. It had been going on for a very large number of years. And the Supreme Court in that case decided that it wouldn't be appropriate to give any firm indication of the kind that my Lord has indicated, but nevertheless it did indicate that Parliament would only have so long without specifying precisely how long that would be. So I don't think in the light of that case law I could say, well, you can't possibly indicate that you think the time has already taken too long and that it needs
I wasn't putting that. I was saying that it appears still to be rather open-ended.
Yes.
And looking at this amendment, which is going to come before the committee in June, July this year.
It doesn't contain a date.
It doesn't contain a date, and if Parliament was worried about that, it could do something about it.
It could.
That was all I was saying.
My Lord, yes, and I agree. Of course, it could. But there's still there's, as I say, a question of propriety, but not terribly stark if it's a general indication.
Well, quite.
Ironically, of course, the inhibition which you say we should feel about laying down deadlines, ironically, that might prompt the neater solution and observe the constitutional proprieties by our making a declaration of incompatibility.
Well, if you make a declaration of incompatibility, that still does not and wouldn't purport to impose a deadline.
No, of course not.
It would still be a matter for them.
Precisely, that's the precise point that I'm making.
Quite. But I mean, and I accept that that's the effect of a declaration of incompatibility. The other thing it would do, of course, would be to open up, and it's probably not terribly interesting in our context, the accelerated procedure under the HRA for Parliament to sort defects in primary legislation by secondary legislation. The reason I say that's not very interesting potentially in our context is because the likelihood is that whatever you do in this area is going to have consequential legislative ripple outs, and those seem therefore rather unsuitable for being dealt with summarily in that way. Whereas if you've got a straightforward binary decision and you can introduce secondary legislation, so be it. So although, as I say, I don't suggest that there's any constitutional objection to the court saying it's taken too long and you need to do something rather quicker than an open-ended thing, there are constitutional limits to that enterprise.
Yes.
That's all. And that the alternative is not a very attractive one, potentially in our context, even though a DOI would open up that accelerated process under the HRA. So the position is, and sorry, the final part of the position, as you know, I know you've seen the command paper, I know you've looked at it, I know you know what it says about the dates and that, but we do now have, is perhaps the punchline, we do now have and have had for some time since the last Loughton bill was introduced, as it were, this entire process under the eye of Parliament. And by this entire process, I mean a realisation that there is a series of legislative options that lie at the end of what do we do with this difference of treatment, and also a question of timing. Has it, in Parliament's view, taken too long since they enacted Section 15 saying, get on with the review as soon as possible? But that isn't, as it were, government on a frolic of its own. This is government informing Parliament as to what it proposes to do, what steps it proposes to take, and the time frame within which they propose to do it. And I don't attach enormous significance to it, but you will know that a command paper is, as it were, the formal communication, a more formal means of communicating with Parliament, the information that is contained within it. And here that is information both about the substantive steps that it is proposed to be taken and as to the timing within which it is proposed to take them. And if Parliament wishes to say, I don't think you're doing the right thing or enough, and we want you to do this, they can say so. If they say, it's been going on for too long, we want to make a decision, they can say that. If they want to say, it should be 2019 and then we expect some legislative proposals to be put before us, they can say that too. So that's the essential history. Sorry to have taken a little time on it, but it's obviously important. And so far as that is concerned, therefore, can I try and pull the strands together, as it were, by making 5 short points on that evidence gathering. The first is that it is an important strand, as you've seen from the command paper, as you saw from the previous Minister for Equality's statement to Parliament in February 2018, set out in our case, and there's a big quote in bold in our case, which you'll recall, I'm sure. It's an important strand which would be considered by Parliament in assessing those 3 options and which way to jump in sorting the difference, to see how the cohort of same-sex couples have reacted now both marriage and civil partnership are open to them, as it were. How many convert to marriage? Now that both options are available to same-sex couples, how many couples afterwards, after the change, would use civil partnerships? And that evidence and those indications were, of course, by definition, not available until a period of time had elapsed after the 2013 Act had come into force in March 2014. So by definition, you wouldn't get that information immediately. So if they're going to regard that as a relevant consideration to help them make the choice, they, as it were, can't do it immediately, they have to wait. And that evidence, we respectfully submit, is important. Before abolishing or phasing out civil partnerships, Parliament is entitled to want to know whether they remain and continue to be considered to be a relevant and valuable institution for same-sex couples. And that is because abolition has the potential to affect them, that is same-sex couples, directly. And so does maintenance, if demand remains strong. It has been asked what knowing the effect of making marriage available to same-sex couples is on their uptake of civil partnership, and what that will tell us about what the effect of making civil partnership available to opposite-sex couples would be. That was a question that my lady asked this morning, and I think I'm right in saying it's a question that my lady has already asked before in a lecture
Might have done.
on this subject. And we give 3 answers to that question. First, it will tell Parliament about the attitude of same-sex couples. And that is relevant as a factor and useful without more. and without needing to answer the question posed by my lady about opposite-sex couples, because the potential impact on same-sex couples of either abolition or less of extension, but certainly of abolition, is obvious. Secondly, it provides at least some evidence, of course recognising that they may be motivated by different beliefs and different considerations at same-sex and opposite-sex couples. It provides at least some evidence as to at least the possible reaction of opposite-sex couples to the use of civil partnerships in circumstances in which both are available. And indeed it might be thought that unless you were to extend immediately, i.e. from the date that Act was passed, to opposite-sex couples, this is the best evidence for the time being, albeit recognising the differences between opposite and same-sex couples for this purpose. And the third answer is that Parliament knows and has known since the very first review that this was one of the strands of work that the government was proposing to do. It was set out in the initial results in the Civil Partnership Review, and they knew it again in February 2018 when the Minister for Equality stood in Parliament and said we're proposing to do and carry on with this work, to take it forward because the early years did not provide a sufficiently clear picture, and it's been set out again in the command paper. And Parliament has not said or done anything to suggest that it is either not content for this line to be considered or would not treat the answers or the evidence it generates as relevant. There were a series of follow-up questions to the question I've just identified, posed by my lady in her lecture, and they were...
I'm sure they weren't all the questions that require to be posed.
They weren't, my lady, but they were obviously matters of interest to my lady, so I think I probably should at least alert the rest of the court to what those questions were. Is there a fear, said my lady, that it will reduce their willingness to marry? That's opposite-sex couples, but why should it if they have such deep-rooted objections to the institution? And why should we mind which they do, as long as they do something? Shouldn't we actually welcome couples who want to enter into a legal commitment to one another, whatever it is? And so far as those questions are concerned, specifically in relation to opposite-sex couples who have a deep-rooted objection, it is of interest to know the true number of those persons and the nature of their views when making the decisions that they don't want to enter into marriage. Relevant for Parliament, of interest to Parliament. For persons like our appellants, the period of investigation and review has the principal effect of enabling the option that they really want, extension of civil partnerships to include them, to be considered by Parliament, with the possibility of abolition, of course, but also with the possibility of extension, which is, after all, what they want. What is clear is that other progressive countries that have considered the issue have answered those questions, the questions that my lady posed, the follow-up questions, by deciding that they don't want to have an institution for those with deep-rooted objections to marriage. And it is clear under the Strasbourg system that they are entitled so to conclude. But perhaps the global answer to the series of questions my lady entirely understandably posed in her lecture are that those are exactly the kind of things that it is for Parliament to consider. And the more informed they are about the choices that then confront them, the better placed it might be thought they will be, even if one can quibble with the precise relevance of some of the strands of investigation. The more informed they are about those issues, the better the legislative judgment is ultimately likely to be. So that's the first. That's why that part of it, in other words, what about the stats? And I've focused a bit on that because it might be thought that it is that which principally has created the length and the period of time that has concerned my lord for entirely understandable reasons. Because you know that when the Civil Partnership Review was done, it was deeply inconclusive in terms of this strand of information gathering. And that was thought to be because the system, the new system, those choices hadn't had time to bed down, and that one needed, as it were, a relatively prolonged period for a more accurate, a more reliable set of indications to exist. Now, one can perfectly happily see the argument that says, why does it really matter? If you end up with 100 or 50 who have deep-rooted objections to marriage, aren't you going to be in the same place? You're still going to have to make a social judgment about whether that's a big enough number, whether those objections are serious enough to warrant only taking the option of extension. But we know that's not what the rest of Europe have done. And it is important, if you're going to go down this road, if you accept that Parliament could decide that this is a relevant strand, it is equally open to it to say, I need a period of time for the picture to solidify, for the new system to embed, for the choices that confront at the moment only same-sex couples, to indicate data of any real value on this. That's the first strand. The second strand, which is important, is to seek to ascertain the views and the numbers of opposite-sex couples. That was part of the evidence gathering in the civil partnership review, as we set out in our case at paras 14 and 15. So after section 15 was enacted, that was always part of the investigative process that was being undertaken. And that was being done because everyone was still considering an extension of civil partnerships with all the potential attractions to people like these applicants. Thirdly, both of those areas, and indeed the other two areas in the command paper, are, I respectfully submit, appropriate and proper areas for Parliament and the government to decide they wish to consider. It can't really be said, and it is not said, I think, that they would not have the potential to assist or inform the choices that they will ultimately have to make. Or more precisely, in terms of the Strasbourg analysis, those strands of investigation are not rationally connected to the aim, which is to gather the evidence base to assist in the informed decision-making that Parliament will have to undertake. And fifthly, and we've explored this already, there is a timescale. It might not be as tight a timescale as the court would like, but there is a timescale of which Parliament is aware. An endpoint for gathering at September 19, the government then proposing which of the three options it would invite Parliament to prefer, and then consultation as to the preferred option in 2020. It is the position, for the reasons that I've explained, particularly to do with that statistical gathering of material on same-sex couples and the move from civil partnership to marriage and so on, it is the position that the picture has taken some time and that we are still some years after the Marriage Act and nothing has yet emerged in terms of sorting this difference. But that is for the understandable reasons that I have given. And I do respectfully submit that although further public consultation will add a further stage to that process, that is an important stage. Indeed, it might be thought that from the perspective of these appellants, it would no doubt be the preferred course if government was minded to recommend to Parliament abolition. These appellants would positively want to be consulted at that point for the purpose of seeing whether they could change their government's mind and invite them to advance a bill to Parliament which said, please extend. And it is appropriate in any event for consultation to occur at that stage, because at that stage, you're not just having an open-ended consultation, you would be having a consultation about a proposal which the government preferred, with the evidence base for that summarised, and for with the reasons for preferring that option explained. It would provide, I'm not going to go back through all the consultation case law, it would provide a target to enable well-informed representations to be made on the basis of an explanation as to why that is appropriate. And I finish perhaps in relation to this fifth point on the basis that although it's taken some time, it is a timetable from here, and it has been a timetable up to here, which has rolled out and continues to roll out under Parliament's eye. Parliament has had its eye on this throughout, succession of private members' bills, the review which it specifically called for in section 15, and now the proposed amendment and the command paper formally communicating that later timetable to Parliament. We respectfully submit that that is a proper period of time, therefore.
When the white paper talks about the review of what has happened in other countries, there's a very nearby other country. Have we got information about that?
A very nearby other country?
The Isle of Man.
I don't know whether they've got information about that at the moment, but they'd presumably be focusing particularly on Council of Europe countries.
Well, isn't the Isle of Man a party to the Council of Europe?
Well, I think it's only in the sense that we are responsible for its international relations.
Yes. Yes.
But
well, it just happens to be a part of the United Kingdom and Islands, which does provide the choice. It seems to be a fairly obvious place to start.
And so does
maybe no information at all.
And so does the Netherlands. My lady, I'm certainly not seeking to exclude the Isle of Man. Let's include them. Jolly good thing too.
It was the first place to start myself.
Yeah, well, I'm entirely content for them to be included, and no doubt Parliament would be too. But the position is that there are some countries which have extended, but they are, at the moment, the Isle of Man and the Netherlands. I might come back on that in a moment. But certainly I wouldn't object in any shape or form, and I don't imagine Parliament would, if you expanded the range of that outside the Council of Europe to include all sorts of other countries around the world and see how they have done things. The point at this stage...
Not the only ones.
No.
Not the only ones.
They're the only ones. In France, for example, le Pacte Civil, I think, is open to couples, whatever sex.
Well, I'm not sure. Well, one can argue the toss about that, right. Whether it's quite the same as significantly lesser rights. I mean, you'd have to explore those issues. But at the moment, this debate is only happening under the headline, is this a legitimate area of inquiry for Parliament to be interested in? To which my answer is perfectly obviously yes, for all the reasons we've been discussing. My ladies, my lords, I was going to move on to and I'm going to take it very, very quickly because I know how familiar you are with A, the subject, and B, my submissions on the subject. I was moving on to margin and discretionary area of judgment. Can I make a couple of short points in relation to that? It wouldn't be too vexing. It's well-travelled territory. They say, that's the other side, say none. No margin, no discretionary area of judgment because the distinctions and the difference of treatment is based on sexual orientation. That is plainly wrong, as one sees from the entirety of the Strasbourg case law. It isn't as simple as that. They certainly have said on certain occasions that in their general principles section of the judgment, strict justification, this is unacceptable, that wording, and no doubt one can understand that where the world is socially set. But we also have seen that in that case law, to focus first of all on the ECHR system, and I'll come to the domestic analogue even more briefly in a moment, but focusing on the ECHR in our context, they have repeatedly emphasised margin. They've repeatedly emphasised margin on the basis that there are social judgments involved, that this is a context which involves balancing rights and interests, and repeatedly emphasised margin, and to some extent treating it as a conclusive feature, where there is no established consensus. And that includes, which is why I emphasised it going through the case law, margin as to, and you'll remember the words, the timing of any changes. And the only circumstance in which they have said so far that the margin has been exceeded, and it's taken them repeated cases and time to get there, is in relation to those core rights of some form of legal recognition to same-sex couples. But everywhere else, even though the distinctions continue to be drawn on the basis of sexual orientation, marriage not available to same-sex couples, a differential set of consequential legal rights and obligations flowing from CP as compared to marriage, with CP only being available to same-sex couples, all on the basis of differences of treatment to do with orientation, margin applies. So we respectfully submit that that's the clear message from the Strasbourg case law. True it is, as I say, and I can entirely contentedly live with this, that when they deal with the general statements of principle, they say strict justification and unacceptable to base things on grounds of sexual orientation. But they say that absolutely alongside of working out how margin applies in a context such as this, where you are trying to deal with, and national legislatures are trying to deal with, evolving and developing social rights and the consequences of that and the differences that they throw up and how you go about addressing and dealing with those. And so far as that is concerned, they all of those cases afford a very broad margin in that context.
I just wonder whether the margin of appreciation has quite the significance that it might otherwise have in view of the circumstances, that there is a limited choice available to Parliament here. In effect, Parliament must either eliminate civil partnerships altogether or must extend them to different gender couples.
My Lord, to some extent I accept that. It certainly does narrow the operation of the margin, but there are still real and difficult and complex social judgments to be made, even as between the narrower options. And I go a little further, because you know that the essence of my justification defence in this case does not depend upon the ultimate choice between those substantive options, but depends upon a judgment by Parliament that it wants to be better informed before it makes it. So there is, as it were, that additional procedural element, which I'm going to come to in a second, if I may. But I accept, as it were, the thrust of my Lord's question, but within those, I know you'll regard them as thoroughly unhelpful limits.
Yes, I mean, essentially you're saying that the government's assessment of how of the information that it requires before it's ready to proceed with a legislative proposal ought to receive a degree of deference from the court.
My Lord, I do, and I'm going to come to it directly in a moment, but just to jump ahead, because I'm almost on the domestic analogue, but I do on the basis that is an approach which is, as it were, well within the Strasbourg system of margin and finds a very clear echo in our own domestic case law. I mean, let's assume for the sake of argument that you treated this simply as a set of decisions which the executive or the Secretary of State was to make. Now, as a matter of domestic public law, a Secretary of State, the default rule, unless Parliament has set out a mandatory lexicon of relevant considerations, see Lord Scarman in Findlay, Lord Justice Laws in Khartoum, the recent case of DSD about the War Boys release, where they analysed all of this set of issues. If you're not in that territory, in other words, where Parliament has prescribed mandatory relevant considerations for a particular decision, the judgment as to what to take into account is a matter for the rational judgment of the Secretary of State under our legislative scheme. And if that is so in relation, if that's the default position, as it were, in relation to the executive, a fortiori Parliament, we respectfully submit, where the court has always been extremely respectful of the boundaries between the court's functions and parliamentary privilege in terms of assessing what they regard as being important. And we know under our democracy, it's a strange old process. MPs can vote for a whole series of different reasons, good, bad, or indifferent, and the court doesn't descend into that territory, see animal defenders. So that's the ECHR position. So far as the domestic analogue is concerned, and there is a domestic analogue called by Lord Reid the discretionary area of judgment, the principles are equally well set. Proper respect accorded in circumstances such as the present in relation to that ultimate decision, abolish, phase out, extend to opposite sex couples, and the basis on which margin or discretionary area of judgment or the breadth of the respect that is accorded are again well established in the case law of this court. Institutional, call it suitability rather than competence perhaps, but institutional suitability, which itself contains that procedural element, which is the better body to make these sorts of decisions and how do they go about doing it, and democratic accountability. And both of those are self-evidently in play here. And I simply identify three factors under our domestic analogue. One, these are considered parliamentary decisions to take time and to call for evidence gathering and review, and then to decide which of the options. And that parliamentary decision is reflected in primary legislation, and if the new proposed amendment goes through, will be reflected further in a slightly different form with its explicit premise in further primary legislation. And that is a subject of interest. In other words, that Parliament has recently considered the matter is evident from the paragraph, I think it was 153 in the judgment of Lord Mance in the M case that I referred you to earlier, and one can get it as well and comprehensively analysed from the judgment of Lord Reid in the SG or JS, the benefits cap case. I'm not going to invite you to go to it now, but it's bundle 2, tab 15, and the relevant pages are 1499 to 1500, paragraphs 92 to 95. So there's been a considered parliamentary decision. Secondly, there is still, and this process is still under the active consideration of Parliament. And if you want an authority, I'm sure you don't need one, but if you want an authority that is of interest in this regard, see the entire set of middle ground judgments in Nicklinson. As Lord Justice Beatson put it below at paragraph 160, it is manifestly clear on the face of the legislation, that's the Marriage Act, that it is not the last word and that the executive and legislative branches of the state will be considering the next stage as Parliament is currently doing. So that's the second point, under active consideration, not just past considered decision. And the third is that this does involve questions of social policy. There is no right answer to the various options, and Parliament will have to judge the need, the demand in society, whether it thinks one option is a better option than the other option for various reasons, and there is democratic legitimacy involved in all of that. You don't need, again, me to remind you, because it's in Lord Justice Beatson's judgment 160, to remind you of the famous statement by Lord Bingham in Countryside Alliance. It would subvert the democratic process, said Lord Bingham, I'm summarising, if people could achieve through the courts that which they recently tried to achieve but failed to achieve through the parliamentary process. So democratic accountability, democratic legitimacy is important, and so is institutional suitability for all of the reasons that are given by, for example, Lord Mance and Lord Reid in the Nicklinson case. See, for that purpose, paras 166 to 7 in the judgment of Lord Mance in Nicklinson, and 297 in the judgment of Lord Reid in Nicklinson. Nicklinson, as I say, is at bundle 3, tab 17, 1621. So those are three particular points on our domestic analogue, and that leads one to consensus. And it is important to focus a little on consensus for the purpose of our justification defence for present purposes. It is important to recognise, so far as consensus is concerned, that the UK is indeed, as I keep putting it, in the vanguard, and has been for some years in this context. We had accorded rights to same-sex couples some years in advance of the ECHR requirement, see Schalk. Those rights are precisely equivalent to the rights that you get under marriage, even though the ECHR permitted differentiation. And we did the same in relation to the right of same-sex couples to marry. By contrast, there is no consensus in Europe to support an ECHR need to recognise, either by way of affording an open institution or by way of affording legal rights and obligations, to those who object to marriage on conscientious grounds, such as those held by these appellants. There is no consensus to support any need to recognise them in that way, or in either of those ways, And moreover, if one leaves the Isle of Man aside, I'm not sure what the position is in relation to them, but only the Netherlands has civil partnerships available to the same and opposite sex couples in quite the way that is anticipated. And even if one includes France with its different rights, you've still got no consensus in relation to that. Indeed, the consensus is to the opposite effect. Not to preserve civil partnerships in that situation once same-sex couples are allowed to marry. And that fact, that consensus to the opposite effect indicates two things. Firstly, that maintaining the civil partnership choice alongside marriage plainly is not required by the ECHR system. There is no incompatibility because that choice is not afforded after abolition of civil partnerships in a country where that choice has been made. That's the first thing. And the second thing is that it is impossible to see how maintaining the civil partnership choice for both the same and opposite sex couples, even when there's been an extension of marriage to same-sex couples, could be anything other than a more finely tuned, more progressive state of affairs from the perspective of this group of people. Indeed, for this group, and the analysis of Lord Justice Bridge defining this group as a special group, whether it's same-sex or opposite-sex couples, is of interest in this. But for this group, that, i.e. extension of civil partnerships to include opposite-sex couples, is the only one that they truly want. It's the only one because they say we object to marriage. So that's what they want. And so the position is therefore that the government and parliament are reviewing and making plans to deal with the difference that exists today in order to consider, alongside the less progressive but evidently more common and evidently compatible option of abolition. And that is a more progressive option which would benefit this group. So there is no consensus, as it were, in relation to that. But in that highly relevant respect, so far as these applicants are concerned, there's, if I can put it this way, no consensus on thoroughly the right side for this purpose. So that's what we say about consensus. So far as social decisions and judgments are concerned, there are, as I've emphasised, a series of decisions that are in play. And Parliament is entitled to have regard to them in the round in assessing the relevant margin. There are the historic judgments that have been made with present resonance in this evolving area, extend the rights but not marriage to the same-sex couples in step one, and create at least, as it were, the potential for the difference that I'm now seeking to defend. Extend marriage to same-sex couples 9 years later in 2014. Decide that you want to take that step as Parliament then and at that time, given its momentous nature, even though, and you're making this decision also, you're not ready as Parliament to make the potentially easier decision to simply abolish and eradicate the difference, but you want to consider the extension option, so you leave it. And the key ones now and in the future review and continue to review with the end of trying to get to plans for dealing with the difference. And then you decide between the options. And I do make the positive submission in relation to this area that substantial respect is properly due to Parliament's procedural choices. And I can make the point shortly because I've made it already. If the common law affords respect, or the respect that is inherent in rationality as the control of the executive's decision-making, DSD, Cartoon, Lord Scarman and Findlay and all of that, then the same must apply a fortiori to decisions of Parliament. And why is that not a set of social judgments for Parliament? Not abolishing the civil partnerships now, even though it would be compatible to do so. Deciding that any legislative choice needed to be better informed than the position was when they passed the Same-Sex Marriage Act in the first place. So that's what we say about margin. That leaves me with two short areas to deal with, and I can pick up the points quite quickly, having gone through in the way that I have. Legitimate aim. Parliament is here considering, I submit, social changes of profound and long-lasting significance. And it is quite evident that it wishes, not just the executive, it wishes to maintain the status quo, even though it has the difference within it. It wishes to maintain the status quo that was created as a result of other such changes, in other words, steps 1 and 2 that I've described. And it wishes to do so for a relatively short period, in social terms at least, in order properly to consider the basis for making another profound social change. And the aim, which we rely upon, is thus to ensure that an appropriate and properly informed decision is taken on a complex set of issues of social policy. And as part of that, to undertake a proper, in its judgment, evidence-gathering exercise to enable it to do that. Lord Justice Beatson in the Court of Appeal described the three ultimate options as raising, as he put it, and we respectfully submit correctly, difficult and sensitive policy issues, and later then described, these are 156 and 158 of his judgment, later described the legal status of civil partnerships as an important matter of social policy that the government and Parliament are entitled to consider carefully. And that is a fact we respectfully submit. In other words, the sensitivity, the social nature, the complex nature of those ultimate judgments is a fact that renders the wish to review and be better cited entirely legitimate. It might be thought that there are two other linked matters underpinning the legitimacy of that aim as identified. And the first of them is avoiding making what might be ultimately seen to be an unwise and less than appropriately informed immediate decision with potentially distressing consequences. And the second matter is the potential for disruption and time, effort and resource associated with making those changes and all the ripple-out legislative changes on day one, immediately the Marriage Act is made, and then remaking them in a different way within a tolerably short period thereafter. That's just not a sensible way of addressing these sorts of profound social changes. And one can ask the question, and it's a legitimate question we respectfully submit to answer, to ask, what is the alternative course? What was the alternative course for Parliament to taking that time to review and increase the information base for the legislative judgment to come? And on my learned friend's principal case, they say that the difference had to be removed instantly on extending the marriage to same-sex couples and thereby creating the difference. But it is evident that Parliament wasn't ready to extend civil partnerships to include opposite-sex couples, and there wasn't any ECHR requirement for them to do so. There's no consensus whatever for that presently in states where marriage has been extended to same-sex couples. And we assume that these appellants do not want the close-off future option if Parliament decides, as it's perfectly entitled to abolish, leaving them with no option acceptable to them at all. So where is the sense in compelling, as it were, an immediate decision in those circumstances? And where is the sense from the perspective of the true objection that these individuals are pursuing, which is to the institution of marriage? They only want one of those options. And Parliament and the government want to consider it. They want to consider the option positively espoused by these appellants. And in order to do that, they want positively to gather information. Now, it may be that that's just because they want to gather information to enable the thing to be better informed. It may be that they think that this would be a parliamentary challenge to get through an extension of this kind, in which case the evidence gathering will be worth the salt, because it will give them ammunition for the purpose of persuading Parliament to go to the option that they favour and that these appellants favour. It matters not. And moreover, if one's asking what's the sense of forcing an immediate decision at the time the Marriage Act is done, if they are entitled to think that it would be relevant, not least because abolition affects same-sex couples just as much as it would do opposite-sex couples, if they are entitled to think, we need to see how the thing is going to bed down and what the stats are going to look like after both options are available, albeit only to same-sex couples for a shortish period. If that's competent for them to have regard to, then by definition they can't act immediately, because they need to see how that picture is going to develop. And it is in that context and with those thoughts in mind that we do respectfully submit that the passage that my learned friend took you to in Hooper this morning is of interest. The relevant passage in Hooper we respectfully submit is in paragraph 62 of Hooper, Bundle 2, tab 14, 1450. But that passage sits alongside the recognition that we've already seen. I'll come back to Lord Hoffman in a second, but it sits alongside the recognition that we've already seen, especially in the context of evolving rights and values, reflected in a lack of consensus about the issues under consideration, a recognition that time to consider and the time before you move from the status quo is acceptable. That was Lord Mance 153 of M. And that is reflected as a constant theme in the Strasbourg case law. Remember the references to time when they were dealing with margin. And Lord Hoffman is of interest because it is considering a position in which the position was historically justified, but it has now lost its justification, as it were, as values have moved. And the principle is that a period of consultation, drafting and debate must be included in the time which the legislature may reasonably consider appropriate for making a change. Leave aside, legislature may reasonably consider, which I respectfully submits the procedural margin afforded to Parliament. The principle is you can take some time to think if you're in that situation, per contra if it had never been justified. But that is our situation, we respectfully submit. Civil partnerships, remember, were open to same-sex couples in 2004 as step one in the evolution. And they were justified at the time, even though they were only open to same-sex couples, as is common ground. It was only when Parliament took step two that that original purpose disappeared, for the reasons that I've identified. But the consequence is that we now have this new difference, but that doesn't render it historically never justifiable. It plainly was at the time. And we do respectfully submit that, therefore, there is a real echo into the reasoning of Lord Hoffman and Hooper. True it is that that comment sits within a passage analysing Walden and Liechtenstein. And I know, and we agree with Lord Reid in his comment earlier on this morning, that often the Strasbourg court, and Marx in Belgium is perhaps the classic example, operates in this field on the basis of legal certainty and prospective effect rather than retrospective effect, contrast the common law and all of that. But that is simply one of the bases, one of the values against which the ECHR system reacts. And we respectfully submit that there is another. And the other is reflected in paragraph 62 very directly, which is that if you accept that you are in an area of difficult social evaluation and choice, it is entirely appropriate for Parliament to take the time that it considers reasonably appropriate to assess the options, to gather the evidence, and then to make the substantive decision. And if you need to cram it in, as it were, to the to the two categories that Lord Hoffman identifies, we are plainly within the acceptable category because it has a justification. When it was first introduced, the civil partnerships, it was justified for as long as it were, it operated until this difference was created. And if anything, we respectfully submit, and I might invite you just to take up the Court of Appeal judgment, if only for this purpose, just to remind you of Lord Justice Beatson at para 157, if anything, our situation is a fortiori, because in the situation that Lord Hoffman was considering, it's para 157 on MS 209, in the situation, as he pointed out, at which Lord Hoffman was considering in Hooper, the government knew what the answer was in basic policy terms, and all it was worrying about was the mechanics of implementing that policy choice. A fortiori here, because Parliament has yet to decide which of the fundamental social change options it wishes to introduce. All the more reason, therefore, for it to be accorded a proper time within which to make that evaluation, and all the more reason to afford it the requisite proper constitutional leeway to decide what it wants to do to inform that decision-making process. So that's legitimacy of aim. Finally, proportionality. I've dealt with the impact on the appellants, and I don't repeat the points I made earlier in relation to that, but that is one side of the balance. It is, we respectfully submit, when judged against the time that Parliament is taking to get to a place of making the decision on these issues, how to deal with the difference, it is, I respectfully submit, relevant to assess the degree of impact on the appellants. And you know that we are not pursuing, have not pursued within the ambit as an argument of Article 8, but nevertheless, the extent of interference is a relevant feature when considering that balance against the time that has been taken. The stronger the interference, the less forgiving the Strasbourg system might be. The lighter the interference, the more forgiving it is likely to be for them to take some time whilst that light interference only is in play. So far as proportionality is concerned, therefore, a central question, it might be thought, is whether there is a less intrusive means. You don't need me to remind you of the usual four-stage analysis from Bank-Mellat and all of that that's set out in our case and is not controversial, I think, for present purposes, but a less alternative solution is the issue to be considered that as effectively meets the aim. That's one of the stages of the analysis. What is it? The only game in town, and it's not really pursued, or it's not, I haven't heard the argument for it, is to say, well, I think it's the point that was put to me by Lord Kerr. Why not have something interim? Why not have an interim solution? Why not bring in abolition, or as he would have it in the question that he put to me, why not extend pro tem whilst you're considering it? And I respectfully submit that that doesn't make any sense. Lord Justice Briggs dismissed it very quickly at 173 of the Court of Appeal judgment by describing the option of opening up civil partnerships to opposite-sex couples whilst considering what to do next as being not plausible. And we respectfully agree it takes only a moment's thought to realise what would need to be done if that's what you were going to do, and to see the ill sense in legislative terms of going down that road whilst in a context such as this, and not least because it might be thought that Parliament and the government, if they want to achieve a particular aim, let's assume that ultimately we get to a stage where everyone says, well, it'd be a jolly good idea to extend civil partnerships. There is a legislative management process to be done, and it does not assist for Parliament to be invited to swing like a weather vane. So that's opening up civil partnerships to opposite-sex couples as an interim measure, not plausible, said Lord Justice Briggs, and we respectfully agree. Abolishing them. Well, abolishing them pro tem carries the real potential for distress and harm to same-sex couples who have entered, who don't want to transfer to marriage. And fundamentally, from the perspective of these appellants, that is not what they want. They do not want that. They don't want it as an interim thing, and they don't want it as a final thing. So that's less intrusive means. And finally, the various criticisms that have been made of the process. I've walked through that with a little care and recognise, of course, that the principal time that has been taken has been to do with that statistical evidence in relation to transferring over or continuing to access civil partnerships. Now the choice is available to same-sex couples. And that's why I took a little time to address the questions my lady posed this morning and in her lecture, because that goes, as it were, to the heart of that issue. Why is it thought to be relevant that that statistical evidence needs to be gathered? Well, as I say, my global answer to that, and indeed to all the other specific criticisms that are made of the process, is that fundamentally these are matters of judgment for Parliament and government under Parliament's eye to take. What information is it, as it were, rationally judged, if one wants to impose that upon Parliament? That's probably, even that is too high a hurdle to impose on Parliament. But what is it that Parliament might consider appropriate for the purpose of gathering information to inform the decision-making about profound social change that is to come? And unless you can get to a place where you say that they couldn't possibly have asked for that information, have called for that information, all the strands of information that have now been formally communicated to them in the command paper, or all the strands of information that they've known were being investigated throughout this process, from the Civil Partnership Review onwards. Unless you get to that place, these are matters properly for Parliament to consider, and that is what they're doing. So my respectful submission is that for all of those reasons, this, and it is an unusual situation because it involves evolving social rights and it involves difficult decisions about whether or not the United Kingdom should be considerably more progressive than the ECHR requires. In that unusual set of circumstances, this is an area where it is legitimate for Parliament to say, I wish to enact to extend same-sex marriage now, that momentous decision. I am not ready to make a decision as to what to do with the difference of treatment that that will create, and I'm going to take some time to think about that on the premise that the difference is going to be dealt with, but I need some time to decide what is the right option. That is, in principle, a legitimate aim, and if that's right, then the question is, have they done that exercise reasonably? My submission is that despite the length of time that has been taken, it has been reasonable as a process. Lady, those are my submissions, unless I can assist further. But there was one further matter you raised. I'm sorry, I didn't mean to point. you raised the question whether there had been a UK case a bit like Ratzenbock. We think there has. We can't quite access, given the wonders of technology.
You can let us know later.
I think it's called Ferguson, the United Kingdom, and it's an admissibility decision, but we'll get hold of it and provide it to the court and my learned friends if that's acceptable.
Well, they seem to have heard of it too.
Yeah, those are my submissions.
Thank you very much indeed, Mr. Reedy. Mr. Squire? Oh, no, one's fine.
Just, I think, a few points. First of all, just some points of clarification. The Ferguson case, my lady, there has been a case, a UK case, admissibility decision brought by some straight couples and some gay couples pre the Same-Sex Marriage Act. Straight couples arguing we should be able to civilly partner, gay couples arguing we should be able to marry, ruled inadmissible for all the same reasons that we've seen in Schalk and so on, not in analogous position, Ratzenberg and so on. But peculiarly, we cannot find the decision anywhere. Ms. Hannett's
doesn't seem to be in HUDOC.
Ms. Hannett's done a full HUDOC search,
Yeah.
so we simply don't know. I mean, we know because it's all over social media and has been for some time. But we just cannot find the decision anywhere. So if we come across it, or somebody, there you are, Mr. Eady will ask his clients and hopefully they'll be able to get us a copy, but we haven't been able to.
Well, it'll obviously be interesting to see it.
Well, according to Ms. Hannett, it's a letter with no reasons. I don't know whether or not Mr. Eady's clients might have more than that, but there we are. We will do, Mr. Eady will no doubt help if he can. Second tidying up matter is the table. Mr. Eady has, if I've understood him correctly, and I'll be forgiven if I've misunderstood him, but I think has repeatedly said that actually, particularly where there's same-sex marriage, there isn't civil partnerships, but in any event, I think he was suggesting that there aren't civil partnerships generally for straight people across the Council of Europe. There are a number of examples. I don't know if your ladyships and your lordships have the table, but there's Austria, for example, so it's introduced same-sex marriage and at the same time extended civil partnerships to straight couples. Estonia has civil partnerships for straight and gay couples. There's PACS. PACS is a slight peculiarity because it doesn't afford precisely the same entitlements, but it does provide state recognition and significant entitlements. And then over the page, there's Luxembourg and Malta and Portugal, which are de facto unions, but nevertheless they're, and the Netherlands, forgive me, and the Netherlands, of course. So it's not the Netherlands aren't an odd peculiarity. There is more to it than that. I'll just pick up a few points, and I hope it's not too disjointed, but I'll just be going through my notebook. This case is very different to the cases that Mr. Eady has taken you through this morning and this afternoon. At one point, Mr. Eady described this as a legacy problem. That might be a way to describe those old cases where justification has diminished, in particular in what might be described as positive discrimination cases, where women are favoured, for example, in pension arrangements because of the social and economic disadvantages they experience. But this is not such a case. The problem here arose from a single act, a decision to enact legislation recently which introduced a discriminatory set of circumstances. That is not a legacy issue. It is a fresh decision. It's not influenced by social evolution, a change in the status of women or gay people, for example. It's a single act attributable to a decision by Parliament to introduce a discriminatory decision or discriminatory factual circumstance. As to the submissions made by Mr. Eady that really one should give little weight to the position of the claimants, for two reasons. One, they are not precluded from state recognition of their relationship. And secondly, because prior to the Same-Sex Marriage Act and the discriminatory circumstance, they couldn't have entered a civil partnership in any event, and that would have been entirely lawful. As to the first, my clients cannot marry, they cannot enter that institution without significantly compromising their conscientious objections to marriage, and that weighs heavily. And secondly, the fact that they could have been precluded lawfully from entering into a civil partnership prior to the Same-Sex Marriage Act says nothing about the position afterwards. They didn't have a remedy before. They do now, because Parliament having chosen to introduce a discriminatory situation, they're entitled to a remedy for that. Parliament may not have been obliged to introduce same-sex marriage or obliged to introduce civil partners for opposite-sex couples, but when it decided to enter into the arena, it was obliged under the Convention to do so in a way which was not objectionably discriminatory. As to the margin issue, that's of no assistance to the respondents in this case. The margin may help determine whether there is a convention violation at European court level at all, but it doesn't help in deciding whether or not, once the domestic courts have found a violation, whether a remedy ought to be afforded immediately. It doesn't grant some discretionary area of judgment domestically, or confer some ability to spend time, or to confer some ability on the, or confer some entitlement on the state organs to decide how to remedy an existing incompatibility. That is a matter for the court, and it is, my ladies and my lords, without wishing to overstate it, a rule of law issue. It is not for the government to tell the court that it will remedy discrimination for which it has no present justification, as and when it decides that the time is right, bearing in mind the information that's available to it. Section 4 provides the right route to that. Parliament's already decided that the way to deal with a compatibility, an incompatibility where time might be required, is to make a declaration of incompatibility and hand it over to Parliament to deal with. As to proportionality, I've dealt with the weight issue so far as my clients are concerned, but it's worth bearing in mind, picking up a point made by my Lord Wilson earlier, that we are potentially talking about something like 9 years before we expect to see legislative change. 2020 before consultation at the earliest. Then there will be a consultation exercise, and then there will have to be legislation passed through Parliament. My ladies and my lords, you'll bear in mind that the time span between the enactment of the Civil Partnership Act and the Same-Sex Marriage Act was 9 years. 9 years to wait to remedy this discrimination, which intrinsically, as it's described, is not justifiable or capable of being justified, is disproportionate, even if the need for time could constitute a legitimate aim. I think that's it. I'm just going to check with our clients as a courtesy. I beg your pardon. May I just have one moment to speak to my instructing solicitor? I won't be.
Yes, of course. Yeah.
Thank you very much.
You're sure you've said everything that
I think so.
feel the need to say?
I think so. I would be in danger of repeating what I said in short form this morning, and I don't think that would be... and we rely on our written case as well, of course.
Yes, of course. Well, we're grateful to you all for your submissions and for the economy with which they have been presented today. And we will now go away and work out what we think the answer is. So the court is now adjourned.